Hey everybody, Jeromy with Civitas Law Group, answering some more questions and responding to some comments from social media today. First off is my old friend James Hewish, who asked about requirements to allow emotional support animals versus service animals in business or medical settings. This one is kind of a loaded question, and I'll tell you for a couple of reasons. Number one, you have two different areas here to talk about. Number one is support animals. The second is emotional support animals with completely different sets of rules. Support animals are a little more straightforward. In fact, the ADA website has a whole lot to say about support animals. First off, support animals are defined as dogs that are individually trained to do work or perform tasks for people with disabilities. So service animals are not emotional support animals. These dogs are actually trained to help people, such as a seeing eye dog for the blind. That's a service animal if it's been properly trained and licensed as one. Second thing you need to know is that service animals generally are allowed to accompany an individual that they are serving essentially anywhere in the business that's open to the public. Where my friend James here asked about medical settings, you can make an argument that as soon as you go back behind those medical doors, that's not technically open to the public. We've reserved, just the lobby for open to the public. Last couple of things you need to know about service animals is that you can ask, if it's not obvious that it is a service animal, you can ask, number one, if the dog is required because of a disability, and number two, what task the dog has been trained to perform. That might sound kind of surprising because it might seem like you're asking, hey, what disability do you have? But according to the ADA, you can actually ask that. The last thing, just as a fun side fact, apparently the ADA has opened up some provisions not just for dogs, but also for trained miniature horses. That's fun. All right, Benjamin Salcido asked about asset and pay protection of an LLC. Asset protection is actually a pretty simple question. LLC means limited liability company. Basically, and there are stipulations we could go into for a really long time, but basically, if you have an LLC, and that LLC gets sued because of something you did in the course of the business that LLC does. Let's say that it's a pool guy and you're out cleaning a pool and you break something and they want to sue you to repair what you broke. They would only be able to access what is actually owned by that LLC. Now there are all kinds of ways that they can break through that LLC protection. So for your own good, go out and learn those. This is a 1-minute video. I couldn't possibly go into all of them. So go out and learn those. But for all intents and purposes, an LLC is a protection because you can only access what is owned by the LLC. Okay, Golson Menchek, sorry if I'm butchering your name there, but asks about HOA fines without any notice and send you a lien on your property out of the blue with officer to your door for last year unpaid special assessment charge of $3,000. So as a homeowner, what is my rights? So here's the problem. Number one, HOAs, they're not government, so they're following really a contract between them and the homeowners in the area. And so whether they were allowed to do this, whether the fines were fair or whether they were acceptable, really depends on that contract more than anything else. Are there laws that actually govern HOAs? Yeah, there's some out there, but most of what they operate under is that contract, and so you have to go and review that contract individually to see if the HOA is operating within their own parameters. Okay, Rose Cortina asks, when you report a documented error of a medical professional to a medical board, does this begin a legal proceeding? Depends on your definition of a legal proceeding. Almost every licensure board will begin an investigation and they will determine should it go to a next step, like a hearing within that board. Whether you call that a legal proceeding or not kind of falls within your own definition. Here's where I really wanted to tackle this one, and I regret deleting this comment, but somebody jumped on here and said, of course not, and every time a lawyer talks about a medical process, they're committing fraud. I was like, well, that's kind of fun, because I guess he didn't see the irony in his own comment that he was actually commenting on fraud, which is actually legal. So he was pontificating on something he really didn't know. So that's interesting. I generally just delete comments like that because I don't suffer fools. But you know what? Next time I think I'm gonna keep it and makes a good video, right? Okay, from Facebook, Alex sent me a picture of a sign, looks like in a gym, that says no filming or photography in the locker room, including selfies, ARS Criminal Code 133019. So that's actually an interesting topic. The code there is pretty long, but here's basically what it comes down to. The reason you can't take a photo or a video or something like that in a gym locker room, including a selfie, is that if somebody's walking by in the background in any state of undress, so they have a towel wrapped around them, their shirt's off, and you say you're taking your selfie because you want to catch those just glistening abs after you got your workout done, and you accidentally catch that person in the background, technically you violated this statute. It's unlawful for any person to knowingly photograph, videotape, film, digitally record, or by any other means secretly view with or without a device another person without that person's consent in the following circumstances, and one of them is locker room. So now, knowingly, a lot of people would say, oh, I didn't know he was in the background. No. It's not knowingly you took a picture of him, it's knowingly you took a picture, period. You accidentally caught that person in the background in a state of undress, you're in trouble. You probably violated this statute. So wait till you get home. Take your pictures at home, and that way you won't accidentally get charged with a felony. Okay, now last time I answered questions from social media, somebody asked me to talk about CCW and no gun signs, and I addressed the question and then got a ton of comments. A whole lot of people saying, oh, Arizona doesn't require CCWs. Arizona doesn't require CCWs. Constitutional carry state. Yeah, you're absolutely right. We are a constitutional carry state. You don't actually have to have a CCW. There are requirements, but having a CCW in Arizona is not one of the requirements of carrying concealed. However, carrying concealed into an establishment with one of those no gun signs, with it properly posted, you can still be charged with a crime, whether you have a CCW or not. I never said it was a requirement to carry in Arizona. I was just commenting on the sign. Okay, now several people, including this one, I'll just call him Pete. Pete, thanks for your comment. He said that it goes into some of the particulars of the statute, saying how big the sign has to be, how big the lettering has to be. There are several particulars of the statute in there, but the mistake that he makes is that he says they have to come to you and ask you to leave first. That's actually not a requirement of this statute. The sign is the request not to come into the establishment with a firearm. So if the sign is adequately posted, if it's the right sign and meets all the requirements and it's adequately posted, that is the request not to come in. They don't have to make a second request. If you're in there and get caught with a firearm, you can be charged with a crime. Okay, one comment from that CCW portion that I did last time. It just simply says, that's if you get caught. Yeah, fun fact, that's all crime, bud. Good job. All right, if anybody else has questions that they would like to see a video on, leave it in the comments below. Otherwise, we'll see you next time.